My name is Jaamall Oglesby. I'm from Winston-Salem, North Carolina, 39 years old. I've been locked up since I was 16 years old for a murder I didn't commit 23 years ago. I was with adult co-defendants, and now they're all free. At the time of the offenses, they were 20, 21, and 28 years old. I was the only juvenile. Today I want to talk about a couple of cases, include my case. The main case is Kellier. In the case, the Supreme Court justice said juveniles can't be held to the same level of culpability as adults in North Carolina. The General Assembly said juveniles convicted only of felony murder can only be sentenced to life with parole. This undermines felony murder as a standalone statute and indirectly acknowledges felony murder as a dragnet statute that applies to more murder cases of people of color than whites. It's in the hands of one, in the hands of all doctrine, and that is not justice. And it's exactly the type of thing the United States Supreme Court was aiming to prevent, trying juveniles who have adult co-defendants for felony murder that's holding the juvenile to the same level of culpability as an adult. And the jury finds the juvenile not guilty of premeditation, deliberation, like in my case. So for them to find me not guilty of the actual murder, but convict me of felony murder means I'm being held liable for the actions of adults. That's the first issue. The second issue in my case is ineffective assistance of counsel. My trial lawyer didn't offer any defense at my trial. We started off with diminished capacity, and we had evidence to present that defense at my trial, but for reasons that I don't know to this day, he ended up withdrawing that defense before my trial started. And so basically we went to trial with no defense, and we fought the best that we could. And even though the verdict was not guilty of premeditation and deliberation, I was still found guilty of felony murder. It was a lot of things that I didn't know and understand about the law that my lawyer never explained to me. The third thing that I want to state is my statement. I made an incriminating statement to the detectives. I had to speak to my mother. At the time, my mom had her own daycare, and my aunt worked there. So when the detectives called my mom, she had a nervous breakdown. My aunt got on the phone. And so it ended up getting misconstrued because my lawyer basically said that he was going to allow my aunt to be the focal point because she was willing to testify. My mom wasn't willing to testify because she didn't think that she could hold it together on the stand. So me not knowing the law and not knowing that her aunt didn't qualify as a parent or legal guardian, that's the reason why my self-incriminating statement never got thrown out. When in reality, I did actually speak to my mother. So my lawyer knew the law though. And by him knowing the law and not going off what I told him, that I actually speak to my mother and bringing my aunt into the equation, that messed my whole, motion up that I tried to file for suppression of my statement, and my statement ended up being used against me at trial. So I don't know how much effect it had, because like I said, I was found not guilty of the actual murder, but it was still used against me as evidence for the state. The last thing, I've been through a lot of appeals, the MAR. I'm on the MAR right now. In 2002, the DA that released me was my resentencing judge in 2019. He removed himself from my case, saying that he couldn't be an impartial trier of facts. He couldn't do my resentencing.
This call is from a North Carolina correctional facility.
And he told me bluntly that I really didn't want him to do my resentencing because he felt like he was responsible for letting me out and that I committed all these crimes and this murder. So he removed himself from the case and another judge from Greensboro came in. So fast forward to 2025, my lawyer filed another MAR based off the Kellier case. That was another juvenile that asked for all of his sentences to be ran together, which is what I'm trying to do now. So if my sentences get ran together, just like in the Kellier case, then I'll come up for parole in 2027. But when my MAR, my appeal made it back to Forsyth County, the same.
You can start.
The third point that I wanted to make about my case was my incriminating statement. My lawyer made my aunt the focal point when he tried to file the paperwork or the motion to get my incriminating statement suppressed because my aunt was willing to testify. My mother wasn't because she didn't feel like she could hold it together on the stand. But by law, that messed me up because my aunt wasn't considered a parent or a legal guardian, so she didn't fit into the enumerated category of people that a juvenile can act.
This call is from a North Carolina correctional facility.
She didn't fit into the category that a juvenile can ask for in order for the detectives to stop questioning me. But at the time, the detectives didn't know if my aunt was my parent or a legal guardian or not. They just disregarded what her status was and told me that she wanted me to cooperate and tell them what they wanted to hear so I could talk to her. And that's what I ended up doing. So I confessed to the murder just so I could talk to my mother and my aunt. The detective, I told him I wanted to talk to my mother first, and I gave him my mother's phone number. I mean, a lot of times we can't have evidence that prove what we're saying, but it's common sense. They didn't have my mother's number on file. So in order for him to talk to my mother, I had to give him the phone number. So when he called and told my mother what I was being questioned for, she had a nervous breakdown. My aunt got on the phone and told them what she told them, and then they came back and told me what she said. Then that's when I confessed. But the whole time I've been telling them, I didn't commit no murder. They didn't want to hear that. They had my co-defendants all down there together. I was the only person that was absent. So all my co-defendants were together being questioned. They was allowed in to congregate together like it's in my police report. That they allowed them to go to the restroom. They allowed them to talk outside together, smoke cigarettes outside. So the whole time they conspiring and getting their story together to use me as a scapegoat because I'm the only one not present, so they don't know what I'm going to say if I already spoke to them. So I ended up getting thrown under the bus and used as a scapegoat. So when we tried to get the incriminating statement suppressed, it got shot down at every level. It got shot down by the trial judge and on the appeal by the Court of Appeals and the North Carolina Supreme Court because technically my aunt wasn't my parent and legal guardian, so by law they said I didn't have a right to have her present. And so my statement kept being used against me. And this is what kept the narrative that I committed the murder because I confessed. But I only confessed, like I say, because I wanted to speak to my family. I wanted to see what was going on with my mother. So it's just another issue that, gives more credence to my ineffective assistance of counsel claim. And the last thing that's going on with my case right now is my MAR, my motion for appropriate relief. When I went back and got resentenced due to the law changes for juveniles in 2019, the DA that was on my case, he removed himself from my case because he was the DA that the judge that did my resentencing in 2019 was the DA in 2002 that let me out the county jail. And 4 days later, all my crimes happened. So he said he always felt responsible. He removed himself and said he couldn't be impartial, and then I didn't want him to be on my case because he didn't feel like I should get out of prison. he don't know the facts of my case. He don't know what happened. All he going off of is what was printed in the newspapers. So I'm already being condemned, by a person who lacks knowledge of what's really going on. He removed himself. Another judge came in and resentenced me. Okay, fast forward to 2025, more changes came to the law, and I filed another MAR to get my convictions ran together so I can get paroled in 2027. The judge denied it in my county. When I got the paperwork and I seen the name on it, I was like, yo, the name looked familiar. Automatically, I thought that it was the same judge that had removed himself from my case. So when I wrote my lawyer and she investigated, called my resentencing lawyer, and she confirmed that, yeah, that was the same judge that removed himself from my case and said in open court that he couldn't be an impartial judge and that he felt like I should never get out. So she filed a motion to rescind his decision and to get me a new judge. The other issue with that is the DA that was trying my case, that was handling my resentencing in 2019, is also a judge now. So I really don't feel like I'm getting a fair shake, in my county. Right now, I'm just trying to get some help fighting, the constitutionality of felony murder for juveniles. So if there's any lawyers or anybody with connections that can help, anybody that's willing to assist me on my journey for justice, please reach out. And at this time, I want to thank Ms. Frankie for allowing me to share my story. I'm at Lumberton Correctional Institution, and I want to close out and say that I'm looking for a church to help sponsor bringing high-risk youth into the prison for my program. I have a youth program. I have a passion for helping the youth because I know what it's like to be thrown away by the system.
This call is from a North Carolina correctional facility.
I know what it's like to be thrown away by the system. I've been incarcerated since I was 16, so I have a passion for helping young people who are going through adversity right now. I really feel like if we can come together and use community collaboration and wrap our arms around the youth and love them back to the right path, that'll be more effective than all these scared straight programs and everything else that's aimed at forcing the youth to do what adults want them to do. Let's create programs to help find out what their skills and talents are, what they enjoy doing, and let's try to help them develop these skills and these talents. That way they can see their value, they can build their self-esteem, and once you do those two things, it's nearly impossible for gang leaders and other negative influences that come and peer pressure these youth to commit criminal activities that land them in prison. So if there's anybody that's interested in that, please reach